Welcome, everybody. Welcome to today's episode of The Law of Self-Defense. Make yourselves comfortable, grab a seat. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you very, very much. That is greatly appreciated. Hopefully, all the streaming streams are starting up. Twitter looks good. Rumble is always comfortable. YouTube is running, and the Law of Self-Defense member dashboard is running as well. And there we go. Also Rumble. All right, everybody's here. This is an open access show, and we're covering the story of a Florida man who did a AR pattern rifle mag dump on his pool boy, completely inoffensive pool boy, 30 rounds, emptied the mag, and the local sheriff in that part of Florida, Pinellas County, gave a press conference recently where he's announced there will be, he won't be charging this Florida homeowner with any charges for having mag dumped 30 rounds at his pool boy. And I thought we would share this event with all of you, provide a bit of legal analysis, and look at some Florida law, Florida statutes and jury instructions that may be relevant here, and maybe come to a conclusion about how reasonable or unreasonable this sheriff's take is on this particular shooting. So with that, let me launch the formal start of today's show. Here we go. All right. We are back. Now, as I mentioned, this is an open access show. We do some of those, one or two of those a week. So it's streaming on YouTube, on Rumble, on Twitter, and of course to our Law of Self-Defense members on the member dashboard. The member dashboard is the only place that we read questions or comments. If you are going to ask me a direct question, I would ask that you preface it with the word question in capitals so it's easy for me to find in the chat. And if you're not a Law of Self-Defense member, most of the content we produce over the course of the week is for members only. And if you're not yet a Law of Self-Defense member, I have to ask, why not? You can become a Law of Self-Defense member for just 99 cents for a 2-week trial, unlimited access to our thousands of blog posts, video analysis of use of force events, members-only podcasts. Again, only members' questions get addressed by me during these live streams. Members also get a transcript of our shows so they can document the knowledge they've acquired in case that knowledge is ever relevant and admissible in court because they've been involved in a use of force event. 99 cents to try it out for 2 weeks, folks, at lawofselfdefense.com/trial. Check it out for yourself, what membership is like. And if you stay a member after that, it's still dirt cheap, folks. It's only about 30 cents a day to be a Law of Self-Defense member. Less than $10 a month, but you can at least try it out for 2 weeks at lawofselfdefense.com/trial. And for those of you who are already members, I would ask you for two things. One, you might pass that trial offer on to your friends and family so we can help grow the Law of Self-Defense community. And you might also consider becoming a platinum member if you're not already. Platinum members are the only people who have access to my legal consult services if they're involved in a use of force event and are facing charges. We don't do outside consults anymore. When we did, they were $10,000 plus, but these days we only provide consults to our platinum members and they get that legal consult for free. So if you want there to be any opportunity for me to be part of your legal defense team, should you be charged in a use of force event, you have to have been a platinum member at the time the event occurred. Doesn't work retroactively, folks. You can get 5 years of that platinum coverage, which includes all the benefits of standard Law of Self-Defense membership, 5 years of that platinum coverage, plus every educational course and book that we produce. It's a giant stack of stuff, $3,000 worth of educational content. You get all that as part of this offer, and the offer is only 82 cents a day, folks. I know you have that in your couch cushions. lawofselfdefense.com/82 cents. All right. And of course, you don't already have to be a member to take advantage of this offer because this includes membership. So you can jump right to this from whatever level you're at now. Okay, so let's take a look at this. Let's take a look at this press conference now. So this is Sheriff Bob Gilteri from Pinellas County, Pinellas County Sheriff's Office. Excuse me. And the press conference is about 35 minutes long. So I'll play it a little bit faster than standard. I think 1.25, he speaks kind of slowly. He's perfectly understandable at 1.25. So we'll get through this in 20 minutes or so. And I'll let him describe the facts. He does a pretty good job of describing the facts. I can't say I agree with his legal conclusion, but he does a fairly good job of describing the facts. So let me jump in there. And let's get this started.
Morning, everybody. Anybody not ready?
Oh, it's kind of quiet.
We're going to talk about an incident that happened on June 15th, 2023 at about 9 o'clock in the evening at 41 Concord Drive.
Started again.
Morning, everybody. Anybody not ready? We're going to talk about an incident that happened on June 15th, 2023 at about 9 o'clock in the evening at 41 Concord Drive in Dunedin. Bradley and Yana Hocevar, Hocevar, and Yana is spelled Jana. Bradley's a common spelling. They're a married couple and they live at 41 Concord Drive in Dunedin, and they've lived there for about the last 3 years. They have a pool in their backyard, and they've used Bay Area Pool Techs as their pool cleaning service for the entire time that they've lived in their home. Their normal pool cleaning schedule is on Thursday or Friday afternoons. But according to the Hocevars, the pool cleaning service has never been there when it's dark out, and certainly not been there at 9 o'clock at night. Carl, with a K, Pollock, P-O-L-E-K, works for Bay Area Pool Techs, and he has been cleaning the Hocevars pool for about the last 6 months to 1 year. So on June 15th, at about 9 o'clock in the evening, the Hocevars were in a bedroom in the front of their residence watching a movie. They both got up again around 9 o'clock to go to the kitchen to get something to eat. As Yana entered the family room area, which is towards the back of the house, she heard noise coming from the back area, the pool deck area, where they have a screened lanai. So the back area is totally screened in. There's doors you have to open to get onto the lanai. So it's kind of an extension of their home through a set of sliding glass doors. And then there's also a side door that gets out to the back area. There were blinds that were covering the sliders, and they were closed. Yana looked out, kind of on a corner of the sliders by the blind. She looked out, and she saw clearly a male subject on their pool deck. Yana said that she didn't recognize the person. There was not supposed to be anybody at their home, not anybody on their pool deck, not anybody on their lanai. And where she saw this person was within a few feet of the sliding glass doors, again, on the pool deck. She said that if she saw this person who was out there, she didn't recognize him, and that he was, again, a few feet away from the sliders and actually moving toward the door. She obviously became concerned at that point. She locked the side door and yelled to her husband, Bradley, that there was someone on the pool deck. Bradley Hocevar stated that he immediately became concerned because there wasn't supposed to be anybody at their home, on their pool deck, etc. The Yana was obviously concerned, and he was concerned that somebody was coming into their home. He yelled to the person to get out or go away several times. They waited a brief period. Yana told Bradley that she still heard noise and that the person was still on the pool deck despite being yelled at to go away. Yana picked up the phone. She called 911, and much of what transpired from that point forward is captured on the 9/11 audio recording that we're going to play for you. There's also video from the Hocevars pool deck camera that we're also going to play. So at that point, after being told by Yana that she still heard noises, and they both believed the person was still out on the pool deck, and again, this is within feet of the sliders, and didn't recognize the person, Bradley Hocevar went to his bedroom and removed his Colt M4 carbine rifle from the closet. Now, this Colt M4 carbine rifle is what most people would call an AR-15 rifle. The rifle has a 30-round magazine. The magazine was fully loaded, but the gun did not have a round chamber. Bradley Hokovar returned to the family room, and Yana was on the phone with 911. Bradley took up a position behind the couch. And so his wife's on the phone with 911. He and his wife are behind the couch looking out, but they really can't see out because the blinds are shut. So all they know is that she clearly saw a guy out there, heard noise, saw the guy coming toward the window. The blinds are shut. He had yelled at the guy to go away, but the person was clearly still there. And at that point, he saw a flashlight. And he saw the flashlight coming toward the house, toward the doors, as if the person with the flashlight was coming into the house. And because of what he saw, that he decided to fire. Now, what I just explained to you, and you'll see it in the video, is consistent with the video because Carl Pollock, who was their pool guy, was on the pool deck with a flashlight moving toward the doors at the time that Hokovar says that's what he saw and he fired. So again, just to kind of recap it, what Hokovar says at this point is his wife clearly saw an unknown male on their deck within feet of their doors. He had yelled at the person and warned them to leave. That the person was moving toward the doors with a flashlight. He was in fear for his wife's and his safety because the person was coming into their home. So at that point, he fired 2 rounds from the rifle. When Hokovar fired, again, the blinds were closed so that he couldn't see exactly who was out there, but he could see the flashlight and knew that it was from a person. And from what his wife saw, the person was moving toward the doors after having been warned to go away. So when Hokovar fired, and you'll see it in the video, it's established that, again, Pollock was on the pool deck with a light moving toward the sliding glass doors. So when Hokovar fired, and you'll see it in the video, Pollock was turning away and he was hit with glass and shrapnel from the rounds. So he wasn't per se shot. He was struck with, in the back, he was struck with shrapnel from the rounds and glass. Pollock immediately ran from the lanai. Yana Hokovar remained on the line with 911 as deputies were responding. And again, Bradley Hokovar still couldn't see out the back windows, but both he and Yana stated that they still heard noise and believed the person was still on the back deck. So 47 seconds after he fired the first 2 rounds, and 47 seconds after Pollock actually ran away, but again, they still say they heard noise out there, Bradley Hokovar fired additional rounds, and then 25 seconds after that, he fired more rounds. In total, Bradley Hokovar fired 30 rounds from the rifle in about 90 seconds. And only the first 2 rounds were fired when Pollock was on the pool deck. The remaining rounds, he was actually gone. So as we talked to Carl Pollock, he was the Hokovar's pool cleaner. He had been in the neighborhood cleaning pools. They were behind schedule, and that's why he went to their home at 9 p.m. Pollock did not knock on the door. He didn't call or make any attempt to notify the Hokovars that he would be entering their back lanai and going on to their pool deck at 9 p.m. Again, when Pollock entered, he did so through a side door. He placed his equipment on the ground, and you'll see in the video, it looks like he waves towards the glass, but the blinds were shut, and Yana Hokovar says that she didn't recognize him at all, had no idea who it was, and she just saw the male figure. And you'll hear that in the 911 recording. It's obvious that she didn't know who it was and that she was concerned. Now, as Pollock was on the deck, and again, you'll see this here in a second, he couldn't see because it was dark. So he briefly goes around the side of the house to look for a light. He couldn't find the light switch, so he came back onto the pool deck and then went back out the side door that he came into his truck to get a flashlight. When Pollock returned with the light, he began completing paperwork. He then moved toward the sliding doors with a light to put the paperwork down. Pollock stated he probably should have let the Hokovars know that he was on their pool deck at 9 p.m. And as I said, Pollock was transported to the hospital with minor injuries, shrapnel, glass that struck him, and he was treated and released that night. So that's a picture of Bradley Hokovar's rifle that he used. We'll go ahead and play the 9/11 tape now. This is the recording, and then we'll play the video. All right, go ahead. It's all captioned up here so you can see it. It's kind of hard to hear some of it.
911, what's the address of the emergency?
Hi, address is 41 Concord Drive, Dunedin. Somebody is just on our line. Somebody is around our house.
What's the phone number you're calling from?
Please come quickly.
Were they walking around the house?
No, they're trying to break me, but I heard them and I saw them, and we don't know if they are armed or not. We just need somebody to come and check on the house. Please.
All right, one moment.
It was the one man that I saw who, I don't know what he was doing.
My name is John. What is your name?
Yana,
Can you spell that for me?
Jan, like November 8th.
And your last name?
I think he's still here. Can you send somebody from here?
I'm already sending them, but I need your name.
Okay. Donna Hocevar, Hocevar.
I already, like I said, I already have help on the way. They've already been dispatched to you.
Okay, so send me the code and, I will give you I can give you the gate code or they can call my number and I'll.
What is the gate code?
One sec. I'm going to. Check. They are sending somebody. I will code. Okay, so. It is a. And.
Okay, did you see the person that's outside?
Just to put it in.
What, is it a white male, black male, Hispanic
They
male?
are, I couldn't tell, I think it was white, but I couldn't tell.
How old did he look?
Maybe 40, 30 younger, not old.
Okay, and what color shirt do you have on?
So he wasn't the one I was completely dark. When I saw him, I took his phone, the person unlocked the door.
Okay, that's fine. How tall did he look?
They had a battery.
And how much did he weigh? What was that?
Not to go to,
What was that? Man,
my husband,
what
it was
was,
my husband.
what was that thing?
It was the,
Who made shot?
they are going around the house.
Who, I need to know what that was.
I don't know how to do it.
Was that a gunshot?
Yes, it was a gunshot.
Who shot it? Who shot it?
My husband, because they are walking around here with the.
What kind of gun does he have? Stop shooting. Stop shooting. Stop shooting the gun.
Stop.
I need him to stop shooting the gun.
Okay, stop. 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 Put it down. Put it on the floor, please.
What?
Put it in.
What kind of gun is it? I don't know. Hello, ma'am.
Stop it, please. Stop it, stop it.
I need him to stop shooting the gun.
Where are you? Where is the?
I need him to put down the gun, ma'am.
I need the police.
Ma'am, I need him to put down the gun.
You put it down. You put it
What
down.
kind of gun is it?
I don't know what to say now.
Is anyone shot?
We don't know. No, you don't want to get out of the house. You know, I'm saying.
What was he shooting at?
I don't know. He's outside. You are waiting for somebody to come and help. Nothing stuff. Come on. Nothing. Send somebody here.
What kind of gun is it?
It's an AR. I need somebody to come in and see.
They're on the way. They're coming as fast as they can.
Please narrow it down. The gun's done. Come here, come here.
Is that police?
Who's here?
Who's here?
Should I go to the front door?
I don't want you to go to the door yet, ma'am.
Okay.
Where did he put the gun away at?
It's on the floor in the bedroom. On the floor in the bedroom. You're afraid because I end up in your house now.
Where is he right now?
I'm in the bedroom. Don't yell.
I need you guys to get out of the bedroom.
You're in the bedroom.
So you guys, no one's in the same room as the gun right now, is that correct?
No, you're not the same with the guy. I'm hiding behind the sofa in the bedroom.
We're behind the sofa and coming. What family room?
In the family room.
You guys are in,
Yes, in the family room.
Is everything okay, sir? Yes. I just need to make sure you don't have the gun with you, that we have that money there.
No, it's in a different room. You're okay.
Okay, are the deputies there?
We don't know.
I want you guys to stay in the house for right now, okay?
Okay,
What happened?
nothing, I don't know.
Yeah, you never shut up. Who fucking?
Yeah.
We were right to open the door if the deputies are here.
No,
One moment, let me.
I don't think it was, because
Yeah, there's something that, oh,
no, 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 shit. No, nothing, please. Please. Okay,
okay, go to the front door, ma'am.
okay. My husband is up there. Yeah, I'm here, my husband.
Okay.
And now this is my dog. Okay, yeah, the front door is here.
They're there? Are the deputies there?
No.
Okay, I want you to stay by the front door.
Okay, we are by front door, let's bring it
I
out.
want you to put your hands in the air. I need you guys to raise your hands up as you come out now. Both you guys need to have your hands in the air
Yes, yes.
and come out the front door. All right, come on out.
Okay,
All right, they'll take over from here. I'm gonna let you go now.
okay, thank you.
She's going to look for the light now. It's dark.
So this is an infrared camera, obviously. The space was not illuminated like this with visible light.
The time on that video is off by 1 hour. They just didn't change it.
And in Florida, this pool would typically be screened in. The walls and roof would be screening to keep bugs out. When you saw the pool guy walk around the corner, he was looking for the light switch. That is believed to be when the homeowners are shouting at him to go away, and he didn't hear them because he was around the side of the wall. Now he's got his flashlight. It is a weird time to do pool. Oh, here we go. So the flashlight moves towards the sliding glass doors. Bam, there's the first two shots. And the pool boy flees there. He's not on the pool deck again throughout this event.
Yeah, you can stop it. Okay. So you can see from the video, and that's really the end of it. He leaves now. And then 47 seconds later is when the remaining 28 rounds were fired. This is a classic example of what's called the castle doctrine or Florida's stand your ground law. Bradley Hokovar was in his home. He was in fear that someone was breaking in. The evidence from the video and from his statements, the audio, his wife's statements on the video, and to detectives that there's no crime that was committed. He was in his home. He was defending what he thought was an intruder coming into his house where he and his wife were. It's an unfortunate set of circumstances. When we talk to pool guy, in hindsight, he should have probably let them know that he was coming at 9 o'clock at night. Again, he made no effort to contact them at all with Pollock. Something I didn't tell you, and I don't know to the extent that it matters, is Bradley Hokovar is a retired lieutenant colonel from the Army. So obviously he was versed in firearms and fighting and firing. But you could tell that they were concerned, afraid for their safety. And with those facts of somebody on your back pool deck, you yell at them, tell them to leave. They're still there. You hear noise. They're within a few feet of the door. And then you see the flashlight, and the flashlight's coming toward the doors. And that's when he fired. And again, it's consistent with the video. So it's fortunate that Pollock wasn't seriously injured. There was a lot of shots that were fired, and the bulk of those shots were after Pollock had left the pool deck. So this is one of those things that I guess if I was going to sum it up, I mean, it's a terrible set of circumstances, but it's unfortunate, avoidable, but it wasn't in this case. It's probably one of those things that I would call lawful but awful. I mean, it's awful, but it's just an awful set of circumstances. But we're fortunate that nobody was seriously hurt. But again, there's no crime that was committed, and Hokovar was acting within the law when he fired. Anybody have any questions?
At what point did he realize that it was this pool guy who had shot him?
So not until after they went out the front door, and you can see there from the 911 call or hear from the 911 call when they walked out the front, is as they walked out front and saw the pool truck in front of the house. And then he had this, oh my gosh moment. But it wasn't until then. He really had no idea until they walked out front and saw the pool truck.
Although this may have been, within the law, was there a better way for the homeowner to have handled this situation?
Under those circumstances, I don't think so up until the first two rounds. After the first two rounds, and again, we've got to be careful in this, that we're not Monday morning quarterbacking, armchair in it. We're not there. We're not sitting in our home with a wife where you clearly see a guy. The guy was in a few feet. You've given him directions to leave. You've given him warnings, tell him to get out of there. You hear noise, and now you have a flashlight coming in. And remember, all this is unfolding very fast. This whole thing is over with in 90 seconds. And he fires the first two rounds, but he can't see out there. And he can't see because the blinds are shut. So he doesn't know the guy's gone. 47 seconds later, and he still hears noise. His wife still hears noise. You can tell from what they're telling the 911 call taker that they still believe somebody's out there. Then that's 47 seconds later. He fires a volley of rounds. And then 25 seconds after that is when he just unloads the entire magazine. If there's room for discussion here, that's where the room for discussion is, about firing that number of rounds in rapid succession and basically unloading the magazine and what would have caused that. But at this point, there's nobody on the pool deck. There's definitely no crime because there's nobody there. And if there's room for discussion, that's where there's room for discussion. That probably didn't need to happen, as we would say in hindsight. But again, we're not there under that tense environment that he's operating under, thinking that somebody's coming into his house, and he's in fear. So, but that's where the room is to analyze it, provide constructive feedback, if you will, or for some criticize it. I don't think there's any room to do any of that for the first two rounds. I think this is about as squarely within the castle doctrine and stand your ground law as it gets.
As a law enforcement sheriff yourself here, would you recommend somebody, because I'm sure we're going to see comments of somebody saying, why didn't you just go look out the blinds? Why didn't you look out another window and see if you can see on something? I mean, what do you think? Yeah, no,
I don't think that's a reasonable suggestion that somebody should have done. When you have that situation, it's 9 o'clock at night, it's totally dark out, and your wife sees clearly a male subject, clearly doesn't recognize him, and you can hear that from the 911 call and tells you, hey, look, there's some guy on our back deck. And this isn't just like an open area. You had to open a door to get in. You're close. You're within a few feet. You're hearing noise. Then you verbalize to the person, get away, go away. You still hear stuff. No, I don't think it's reasonable to say, oh, well, put yourself in harm's way. And what do you do? Just peer out. And you don't know if the person's got a gun. You don't know what their deal is. And also, concerned if the circumstances. You don't know if they're there to get him personally. You don't know if it's a property crime. You don't know what it is. I'll tell you what experience does tell me is that tells me that, not necessarily him, is that most people who commit property crimes, when they're confronted, they flee. Okay, but those are thieves. Those are burglars. But there could have been something more here, a lot going in his mind. Again, he's got a military background. There could be somebody there that was there to get him for some reason. He's got a lot of background, and so I don't think that's reasonable. No, I don't think anybody should do that. I would never suggest that somebody do that because you could end up getting yourself shot.
In talking with the pool cleaner, did he acknowledge that he heard the homeowners inside telling him to leave?
No, and we don't think he probably did because we're trying to match this up. Again, the 911 call gives us the audio and the video is from the camera, but the audio and the video aren't exactly in sync and matched. And the best we can tell, again, I'm just saying that the best we can tell is when he was verbalizing is probably when he went around the corner to find the light switch. So best we can tell, he probably didn't hear him verbalizing. That's why this is one of those just, situations that in some cases, everything just lined up imperfectly. The only thing that lined up right here is that Pollock didn't get shot. That's a good thing given these circumstances. But other than that, it's just a calamity of situations that lined up, and that's why I say it's awful but awful. It is awful, but we're fortunate that Pollock didn't get shot. But that's what we think.
What were the injuries that he faced? What were those from?
Yeah, shrapnel. So the rounds fragmented as they're going through the glass. So it's fragments from the rounds from their 223 rounds, 223 caliber rounds. So they fragmented in the glass. So we got hit with the glass. Basically, superficial cuts is what they are. And some of the shrapnel was still in, and the doctor said it'll naturally come out. So he wasn't shot. He was hit with, if you will, flying debris, glass and shrapnel. So basically cuts. Very fortunate.
Now, is it normal for these pool companies to just come out, at different hours, or are they usually on this set schedule, or?
I don't know. I guess it depends on the pool company you use, but all I can tell you is what we knew here. And what we knew here with this pool company is that they came on Thursdays or Fridays in the afternoon. They never came after dark, and certainly never at 9 o'clock at night. So this was totally out of any norm whatsoever. And there's no way under any circumstances that Yana or Bradley Hokovar would have known, could have known, should have known, and thought, oh my God, well, that's the pool guy on the back deck. No, I think that their reaction to this, given 9 o'clock at night with everything that I described to you, is a very normal reaction. It's the reaction that most all of us would have had given those circumstances, especially when she looked out and she didn't recognize the guy. She didn't see him, or she saw him, but she didn't recognize him. Couldn't put it all together. It made no sense to them. And then you put it together with the verbalization to get out. He doesn't get out. He's close, gets the light. And you can see in there where the flashlight does come. And what Bradley Hokovar says is that when he fired is because the light is now coming toward the door and he thinks the guy's coming in. And you can clearly see that from the video. He's there with a light and he's moving towards the doors. And that's when he fired. And the gun did not have the slight delay there is, and somebody wanted to look at it like really closely and critically, you'd say that, well, he actually fired when Pollock was actually turning around and moving back, but there was not a round in the chamber. So it wasn't like he was sitting there and, anxious to shoot. He had the magazine that was loaded, but he didn't have a round. He had a rack of rounds. So he hadn't decided when he took that AR out, it wasn't like he was sitting there and he had decided, I'm going to pull this trigger. He was sitting there. He was waiting. And what was the event that caused him to fire was the flashlight. And he thinks the guy's coming in. So he puts one in the chamber and racks it and then fires. Which again cuts to, this wasn't a guy that was sitting there trigger happy wanting to shoot. He was trying to protect himself and his wife, and he was concerned about the circumstances.
How lucky are we that the deputy wasn't close by, might have arrived a minute or two early, in between that first two shots and before he emptied the round?
Well, there's a lot of lucky in this thing. Also, lucky because the facts are the facts is he also fired, after the first two rounds, he fired 28 more rounds that went out the back of that house, that they didn't go somewhere. There wasn't somebody else around. One of the things that certainly caused this, if you will, and I put that in quotes, was it was 9 o'clock at night. The good part about it was 9 o'clock at night, there's not a lot of people around. There's not, those rounds and 223 rounds, those rifle rounds will travel a good distance. So there's a lot of good things, that didn't happen here as well. That it could have been much worse.
So those rounds didn't hit anything else that didn't fire off?
No. No, I mean, look, I'm not trying to, but you guys are going to go out there. Probably all of you are going to go from here out there is what you're going to do. And you'll see that behind there's a shuffleboard court. So if it was 2 o'clock in the afternoon, which I'm sure you all will get into the what ifs of that, but it was 9 o'clock at night. But yeah, there was. But to answer your question is that thankfully there's nobody out there. And a lot of the rounds we couldn't find because they travel such a good distance. Those rifle rounds will travel. So we couldn't find them. All the shell casings, of course, were recovered inside the house. Anybody got anything else? All right, thanks.
Okay, so the pool boy was not shot, which is good. And this is a picture of the actual house where the shooting occurred. That's the pool near the bottom there. This is a north-south view, up and down vertically. And we can tell, we can match that up with the video. here. So we see the pool is this would be south from the left to the right here. The direction the shots were fired would be heading south down the long sides of the pool. Here's the long sides of the pool. So the shots would be running in the direction towards the bottom of this image. Okay. If we take a look, because I did take a look, I went to Google Earth and I checked it out. Here at the top is the house with the little red lollipop and the red arrow there. Those rounds would have been flying out the bottom, the south end of that house, into this neighborhood. Now, apparently, there's a shuffleboard court here in the trees, but these are all homes and streets where people drive and walk their dogs. So this guy wasn't in the middle of nowhere. He wasn't on the ocean. He wasn't in the desert. He wasn't in, Florida has some pretty big areas in the middle of the state that are pretty barren terrain, but this is Tampa, basically. So this would be kind of the zone of fire that these 30 shots were traveling through, fired out of that AR. And I would encourage us, now we'll take a look at some actual Florida law, see what kind of legal justification there would be for firing those rounds. And I would encourage us to distinguish between the first 2 rounds and then the other 28 rounds that were fired. Because I can't see any justification for the other 28 that were fired at all. Maybe an argument can be made for the first 2, although I think that's fairly weak. I would also point out this pool is screened in. So these little Florida pools right outside the house, typically part of, they call it a lanai. It's a screened in area. So there's walls that are screened. The roof is screened. There's a little screen door to get in. And so you could argue that the area around the pool is part of the residence. If it was an attached garage, you would certainly say it was part of the residence. I think that argument is weaker with a screened-in porch, a solid attached garage, very similar to a home in terms of providing protection from the elements, protection from others, privacy. A screened-in pool area doesn't really do any of that. You can just walk through the screen. But nevertheless, it's certainly part of, if nothing else, the curtilage of the home. The sheriff talks about how the relevant Florida law here would be castle doctrine or stand your ground. That's really completely irrelevant to whether or not these shots are fired. The person in his home would have no duty to retreat from an intruder. That doesn't mean they're privileged to just shoot rounds out of their house into the neighborhood. But if we look at Florida law, let me open this up. So what could be the legal justification here? Let's take a look. Relevant Florida statutes. Well, first we have their core self-defense statute, which is 776.012. The first paragraph here deals with the use of force except deadly force. So that's the non-deadly force paragraph. And paragraph 2 deals with the use of deadly force. Obviously, the AR is a firearm being fired, so it's deadly force. A person is justified in using deadly force if he reasonably believes that using such force is necessary to prevent imminent death or great bodily harm to himself or another, or to prevent the imminent commission of a forcible felony. A person who uses or threatens to use deadly force does not have a duty to retreat and has the right to stand his ground if the person using the deadly force is not engaged in criminal activity and is in a place where he or she has to be. So that's really just setting out the 5 elements of self-defense, right? You're defending yourself against death or great bodily harm or a forcible felony, that's innocence. The requirement that the threat is imminent, that's imminence, that the threat is death or great bodily harm, or a forcible felony, which implies death or great bodily harm, that's proportionality. Avoidance is covered with not have a duty to retreat. And then we get to reasonableness. So a person is justified in using force when they reasonably believe that such force is necessary. A person who uses such force does not have a duty to retreat. But really, here's reasonableness here, the requirements that you reasonably believe. But of course, reasonableness has 2 subcomponents. Subjective reasonableness, you had a genuine good faith belief in the need to act in self-defense, to use that force, deadly force here. But subjective belief, however genuine and good faith, is not alone enough. That belief would have to be shared by a theoretical, reasonable and prudent person in the same circumstances. An irrational subjective belief, a speculative subjective belief, is not objectively reasonable. And therefore, you would fail the element of reasonableness. You would fail self-defense. Here we have to ask ourselves, if we're looking to this 776.012 to justify the firing of any of these shots, where was the apparent threat presented by the pool boy to the homeowner personally that would constitute a reasonably perceived imminent threat of death or great bodily harm? I mean, they literally had no interaction, person to person, at all. You might say, well, the pool boy was reasonably perceived as about to engage in the imminent commission of a forcible felony. What's the forcible felony? I mean, an intrusion into the home would be a forcible felony. Are we to say that walking towards the sliding glass door holding a flashlight, never touching the door, never attempting to open the door, never banging on the door, that alone is sufficient for a reasonable person to perceive an imminent forcible felony? I think that's a hell of a stretch. Even for the first two shots, it's a hell of a stretch. Is it any basis for the other 28 shots that were fired after the pool boy left and could not have been presenting as any perceived threat either to the individuals or the home? So I think you might have some argument if you were willing to accept that the pool boy walking in the direction of the sliding glass doors could reasonably be perceived as someone imminently about to commit a forcible felony, the essentially the burglary of the home. I think that's a hard sell. I don't think that's enough. I think if the pool boy had tried to open a slide glass door, had shaken it even, that's an apparent attempt to entry, but I don't see any apparent attempt to enter here. So, and certainly for the next 28 rounds, I just see zero justification under 776.012. So then there is a standalone justifiable homicide statute in a different section of Florida crimes, 782.02, justifiable use of deadly force. It reads, the use of deadly force is justifiable when a person is resisting any attempt to murder such person. There's no evidence of that here. And remember, when we talk about objective reasonableness, folks, reason is the application of your powers of reason to actual evidence, things you're observing or hearing. It's not speculation. It's not imagination. This sheriff spends a lot of time at the end talking about, well, he could have had a gun. He could have had a knife. That's not a reasonable conclusion. That's a speculative conclusion. That may be a concern sufficient to arm yourself with that AR rifle and cycle around into the chamber. But speculation is not a justification for the use of deadly force on someone. So in resisting any attempt to murder or to commit any felony upon him or her or upon or in any dwelling house. But again, what's the evidence that the pool boy was attempting to commit a felony on the dwelling house? That's not speculative. Maybe for the first two rounds again, but for the 28 rounds after the pool boy had fled and wasn't even present, I just don't see it. Then we get to another possible justification, and that's home protection. So this is when I talk about highly defensible property, this is what I'm talking about. So a person who's in a dwelling or residence has no duty to retreat and can use force. First, they talk about non-deadly force, then deadly force. If he reasonably believes that using that force is necessary to prevent imminent death or great bodily harm, or to prevent the imminent commission of a forcible felony. So it's really just repeating here the the self-defense language from 776012. But then we get to the good part. The good part of highly defensible property is a legal presumption that the defender had a reasonable fear of imminent peril of death or great bodily harm. Well, look what you're getting here. It's presuming reasonable, one of the 5 elements. It's presuming imminence, a second of the 5 elements. It's presuming death or great bodily harm, so that's proportionality. You already don't have a legal duty to retreat. No duty to retreat, so that takes care of avoidance. So that's 4 of the 5 elements of self-defense. The only one not explicitly addressed is innocence. And if you're defending yourself against an intruder into your home, innocence is kind of baked into the cake. But this legal presumption, so you're really getting all the elements you need to justify your use of deadly force in the context of highly defensible property. It's amazing. But there are conditions to triggering this legal presumption of a reasonable fear of imminent deadly force harm. That's what this if is for. If the person against whom the force was used was in the process of unlawfully and forcefully entering, or had unlawfully and forcibly entered, a dwelling, residence, or occupied vehicle, or if there was a kidnap attempt. And the person who used the defensive force knew or had reason to believe that an unlawful and forcible entry occurred. Well, you may argue there was an unlawful entry if you count the screened-in pool area as part of the dwelling, and the pool boy ought not have been there at 9 o'clock at night. He probably didn't know that. He probably thought he had license to go to the pool, even if he was running late in his daily work. But maybe the homeowner would have thought, no, 9 p.m. at night, I wouldn't want the pool boy here. So he's here unlawfully. He's here without license. But where's the forcible entry? I mean, in my experience, these screened-in areas, the screen doors aren't locked. There's no evidence that the screen door was forced. And the reason these laws require unlawful and forcible entry is precisely to deal with this scenario. The innocent intruder, someone who may be present unlawfully, but is not present with malice. They're not there to do harm. So it's not enough that they're unlawfully for purposes of this legal presumption. They also had to have broken something to get in, because there may be explanations for why there's an innocent intruder. Like here, the pool boy was simply running late. But there's no innocent explanation if he breaks something to get in to the pool area. So if the screen door had been locked and he'd forced it open, well, I think this legal presumption would be triggered. But not only did he not do that, the homeowner can't claim that he had reason to believe that something was forced. Now, we could imagine a situation where, I don't know, there was no screen door into the pool area. It's just completely fenced. So you have to breach the screening in order to get in. There's no way to get in without forcibly entering. Well, then the homeowner, the mere presence of the pool boy around the pool, the homeowner could say, well, it had to be forcible. There's no non-forcible way to enter that area without coming through the house itself. But that's not the case here. So I don't see this providing even the legal presumption of a justification, especially for the 28 additional shots. Then we have sorry, folks. So this is 776013, defense of highly defensible property. Again, we just talked about this. Deadly force. A person who's in a dwelling or residence has no duty to retreat, can stand his or her ground, can use deadly force pretty much under the conditions of the self-defense statute to prevent death or great bodily harm, commission of a forcible felony. And then the legal presumption. They're presumed to have had a reasonable fear of imminent peril or great death or great bodily harm. And then the conditions. If the force is being used against, unlawfully and forcibly entered, and if the defender had reason to know that they had unlawfully and forcefully entered. And I don't see any of that here. Then we have 776031. So this is Florida's defense of property statute. Basically, they have non-deadly force in defense of mere personal property, and then they have the deadly force section. A person is justified in using or threatening to use deadly force only if he or she reasonably believes that such conduct is necessary to prevent the imminent commission of a forcible felony. But again, it would have to be a reasonable belief of a forcible felony. What's the evidence of a forcible felony? That someone could apply their powers of reason and conclude that an imminent forcible felony was taking place. If there had been banging on the sliding doors, maybe, but there was nothing like that here. A person who uses or threatens to use deadly force does not have a duty to retreat, can stand his or her ground. If they're not engaged in criminal activity or in a place they have a right to be. Let's see what else. So the sheriff may have been thinking that the legal presumption was triggered here because the pool was part of the home, but he's missing the whole requirement of the objective reasonableness of a forcible and unlawful entry. So what might this homeowner actually be guilty of? Well, some force of reckless endangerment. And Florida has a specific statute on this, 790.15. Discharging a firearm in public or on residential property. Let's see. Any person who knowingly discharges a firearm in any public place or right of way of any paved public road, highway, or street, who knowingly discharges any firearm over the right of way of any paved public road, highway, or street, or any occupied premises, or who recklessly or negligently discharges firearm outdoors in any property used primarily as the site of a dwelling, commits a misdemeanor of the first degree, punishable as provided in 775082. I'm surprised it's not a felony if they do it with a, misdemeanor of the first degree. So there is, of course, an exception for lawfully defending life or property, but we just went over those justifications, and I don't see them as applying here. And frankly, I'm surprised it's not a felony. In most states, it would be a felony, the felony reckless endangerment, because again, this is where those shots are going. That red triangle, out the south wall of that home. Lots of residences there. AR bullets can penetrate other homes. It's true they're deflected, but when you're firing, easily deflected by materials, but when you're firing 30 of them, they don't miss. Bullets don't miss. They keep going until they hit something. It just may not be the intended target. So the pool boy was not hit by any rounds. He was hit by some bullet fragments and some glass, so he'll be fine. Should he have knocked on the front door and let him know that he was there at 9 o'clock? Probably, but that's got nothing to do with whether or not the use of deadly force by the homeowner was justified on the facts of this case. The fact that the pool boy might have been imprudent doesn't create a magical justification for the use of deadly force by the homeowner. The fact that the homeowner was, I guess, a colonel in the Army, the sheriff said, also completely irrelevant. You don't get some special justification of self-defense because you were a colonel in the Army. And one of my neighbors was a colonel in the Army, and he was a band leader. Not to diminish his service, but it's not like he was a combat expert, my neighbor. So just the fact that this homeowner had been a colonel in the Army doesn't mean he knows anything in particular about firearms. Certainly it doesn't appear so in the way he used it, right? 2 rounds, then 45 seconds, another few rounds, and then 20 seconds after that, when he could not possibly have been perceiving movement or noise out on the pool area because the pool boy was long gone. Then he empties the rest of the magazine into his community. How can that possibly be reasonable when there's literally zero evidence of any threat whatever, because the one person who'd been there who was never a threat in the first place was gone and couldn't even be mistakenly perceived as a threat? Let's see. All right, let me dive into some of the comments now. And while I'm doing that, I'll put up our little, because this is an open access show, it's not limited to Law of Self-Defense members. Most of our content is limited to Law of Self-Defense members. I got them monetized on YouTube again, just for playing, I think, four or five use of force videos where not a shot was fired. So thanks, YouTube. Much appreciated. So if anything, even more of our content is going to be limited to the Law of Self-Defense member dashboard at Law of Self-Defense. And you can try out Law of Self-Defense membership, 2 weeks, unlimited access to all our member content for just 99 cents, folks. And after that, it's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. So I would encourage you to take advantage at least of this trial opportunity at lawofselfdefense.com/trial. So why wouldn't this sheriff want to bring charges here? I mean, he could. There's more than enough probable cause for reckless endangerment. So a lawyer friend of mine in Florida, who asked not to be named, he's actively practicing, but he suggested something that could be the case. There are these sheriffs and sometimes prosecutors that genuinely believe the boundaries for self-defense have been made too broad by the legislature. They don't like their own state self-defense laws. And so sometimes they'll make a charging decision. Usually it's a no charge decision in a case that could readily be charged in an effort to, and they'll say, well, I can't charge. The law prevents me. These crazy self-defense laws the legislature has passed, these crazy stand your ground and castle doctrine laws, they're preventing me from doing what I wish I could do, which is charge this person. So maybe you should call your legislators and have them constrain the privilege of self-defense. This happened in that case up in, I forget now where it was. Oh, Missouri, where the fireman had put an apparent chokehold on a bad dude who'd come at him with a gun. The bad dude drops the gun. The bad dude's girlfriend picks it up and shoots the fireman. And then the girlfriend was not charged for shooting the fireman. And the prosecutor there said, well, nothing I can do. Missouri self-defense law says this is okay. Did it really, though? I mean, do we know? Because it was very ambiguous to me. They deliberately left the facts that would control that decision out of the media. It might have been lawful for the girlfriend to shoot the fireman. Maybe not. But the prosecutor just treated it as, no, this is just what's allowed. Maybe you should get your legislators to constrain the privilege of self-defense in Missouri. I'm a Soros-funded prosecutor. I would love for you to have less self-defense privilege. So maybe that's what's happening here. I should also mention, by the way, that the sheriff here is not the ultimate arbiter of whether or not this homeowner is charged. The local prosecutor can just charge this guy if he wants to. He's not bound by what the sheriff decided in this press conference. All right, so the Law of Self-Defense chat. Again, another benefit of being a Law of Self-Defense member is it's only from Law of Self-Defense members from our member chat that we address questions and comments. So if you're commenting on YouTube and Rumble and Twitter, that's fine. Feel free to do that. But I don't look at those. Jeffrey says, comments, just started the Law of Self-Defense instructor program. I had to look up my notes on John Locke. I haven't even looked at that in 20 years since I taught political theory. Hey, that's great, Jeffrey. So for those who don't know, Law of Self-Defense has an instructor program. It's the equivalent of a law school level semester-long course in self-defense law. If I were teaching use of force law at a law school, as if I could survive the political environment of a modern day law school, but let's pretend I was teaching a semester-long seminar on use of force law at law school, our Law of Self-Defense instructor program is what I would be teaching. It's about a 15-week-long program. There's reading assignments, like Jeffrey mentions John Locke. There's case law that has to be read and debriefed, or briefed, I should say, by the student. It's a great course, intended primarily for people who are self-defense instructors and who are asked use of force law questions, hypotheticals by their students, so they can provide, I mean, you can't practice law, obviously, but you can at least authoritatively illustrate for the student asking the question what the right question is to ask and what the legal issues would be. If anyone's interested in that, let's see, where can you find that? You can find it at, I think, I'm just going to wait for the page to load here. Yeah, at lawofselfdefense.com/instructor will take you to the website for the instructor program. All right. Gary asks, roughly what percentage of jurisdictions around the USA would come to the same conclusion as this Tampa sheriff? You know, sheriffs are politically elected, so they're really politicians, and they engage in political decision making. So they make charging decisions based not just on legal merit but also politics. So it would depend on the, I don't know the political mindset of all the jurisdictions sheriffs in the country. Any of them could. It would be at their discretion. Gary says, has anyone mentioned where those 30 bullets ended up? Is his neighbor's house Swiss cheese now? They went somewhere, right? Every one of those 30 rounds went somewhere, not into the pool boy, thankfully. Leroy Ortiz, keep the doors to your property locked. Yeah, so if the homeowner had locked the screen doors on the outside of the pool area, well, then the pool boy would not have been able to come in innocently, could not have been an innocent intruder at 9 p.m. And if anybody was there, the homeowner could say, no, I knew they had to force something to get in because we keep those screen doors locked. But of course they don't. Question, if one bullet did hit someone downrange, what would he be charged with if he was killed or just injured? Well, if the person's killed, the appropriate charge would be reckless manslaughter. Recklessness, again, is the knowing creation of an unjustified risk of death to someone and deliberately ignoring that risk. That's what he's doing here. Sometimes it's crafted as what's called criminal negligence. So negligence is only sufficient for civil liability, not a criminal charge. But if you're engaged in negligent conduct while handling an inherently dangerous instrument, which a firearm is, it automatically bumps the negligence to recklessness. Sometimes they call it criminal negligence, but criminal negligence just means recklessness. So it would be a reckless manslaughter if someone were killed. If they were just injured, reckless battery, aggravated battery, I suppose. And even if nobody was hurt, it's reckless endangerment. You've put people in danger of death or serious bodily injury. Let's see. Gary talks about the pool area being screened, and maybe the sheriff considered that part of their residence. I think we already talked about that. Jeffrey says, couldn't see the target and mag dumped, even after the guy left. Recklessness all the way. That's how I see it. Joe, so where did those other 28 rounds that he fired blind into his backyard end up? Yeah, in that community. Oh, here's a good point. Why is that 911 operator telling him not to shoot when he does not know what is going on? I expect that the 911 operator was concerned that the homeowner was shooting at the police that had been dispatched to the house, and he didn't want them lit up with 30 rounds of .223. But in general, yeah, the 911 operator should not be giving absolute commands to the homeowner because the 911 operator is not on the scene, doesn't know what's going on, and often can't get a very good idea of what's going on from the callers, like we saw here, right? The wife is on the phone. She's very confusing in how she's communicating information. The husband's an actor, not on the phone. He's clearly, from my view, panicked, making panicked decisions, not reasoned decisions. So I expect that's what was motivating the 911 operator. Normally, they don't give those kinds of, well, they're not supposed to. It's not prudent. Yeah, Eric says, I like how the 911 guy is like, don't shoot, like he's there and knows what's happening. Yeah, just not. Tony says, new law of self-defense instructor graduate yesterday, June 27th, 2023. Congratulations, Tony. That was, as I know you'll attest, it was quite a bit of work, but I expect you learned a great deal. Gary says, cops taking their sweet time getting to the house. It can take the cops a long time to get to a house, folks. Too long. often. Let's see. Yeah, so if the whether or not the screened-in area of the porch, the pool area, the lanai, would count as part of the dwelling, I think is an open question. I could argue it either way. There is an enclosing structure. It is attached to the home. I would argue that's really no different than a attached garage. On the other hand, I could argue, but it's the function it serves is very different. There's really no privacy. There's no real security. You can just walk through the screen. Now, it would be part of the curtilage of the home, but the curtilage does not trigger the legal presumption of reasonable fear of imminent deadly force harm because it requires some kind of breach. So just curtilage alone, there's no physical breach of the home if someone's just stepping into the curtilage. It would relieve the homeowner from a legal duty to retreat under the castle doctrine. If they were in their curtilage, they wouldn't be required to retreat in their curtilage either, but it wouldn't give the homeowner additional privilege to use deadly defensive force. Robert says, apparently there was a video camera that the homeowner never bothered to check. So like a Ring type camera. Could be. Jeffrey says, bet the pool company changed their policy to call first or made their employees follow the policy. Yeah, I expect they probably have that policy. But I don't know. I've never worked for a pool cleaning company. Paul says, that's why I have cameras to look at who's out there. Yeah, folks, I have to say I have cameras all over the exterior of my home just for that purpose, as to provide me with tactical intelligence about what's going on outside my home. And some of those cameras are looking at the home so I can see behind people, right? It's with the Ring camera, often the doorbell type camera, you're seeing the front of the person, but you can't see what's behind them. You can't see what's to either side of them if somebody's hiding. Zachary says, if the pool guy was dead and the homeowner fired 28 extra shots 50 seconds later, I seriously doubt he goes uncharged. I'm shocked that he's not charged for those 28 rounds, at least with reckless endangerment. You want this guy in your neighborhood? Let's see. Yeah, Philip says, Lieutenant Colonel in the military, what branch? I believe they said Army. A lot of difference between a combat arms officer and a service support officer. Yeah, of course. Sure. Joe says, this looks to me like a perfect storm of idiocy. The pool guy should have called ahead or at a minimum rung the doorbell. The homeowner violated several of the basic rules of gun safety, starting with not being sure of his target or his backstop. Yeah, so I mean, I have to say, if I'm looking at my front door from inside my home and it's starting to get splintered out of the frame, someone's obviously forcing their way in. Might I take a shot through the door before it's completely open? Maybe. I might. I mean, but there's no ambiguity about what's happening there, right? No one's innocently kicking in my front door. And if it's police, presumably they're shouting police. But nothing like that was happening here. Eric says, the first two shots seem justifiable. Maybe. I mean, you have to keep in mind, of course, in fairness, the first two shots, if we were doing a preponderance of the evidence test, 51%, one way or the other, it would be a close call to my mind. It is true, of course, that the state would have to disprove the justification of those first two shots beyond a reasonable doubt. And the prosecutor might say, well, that's going to be hard to do. It's a high burden, high threshold. If this guy gets a competent legal defense, like he would get if he was a platinum member of Law of Self-Defense, which he could be for just 82 cents a day at lawselfdefense.com/82 cents, then he might be very difficult to convict on those first two shots. I expect I could make him very difficult to convict on those first two shots. Unfortunately, he didn't stop there. Let's see. Philip says, also, most field grade officers, major, lieutenant colonel, unless they're hunters or competitive shooters, probably haven't touched a firearm in years. Yeah, this notion that because someone's a law enforcement officer or was in the military, that we can then safely presume that they have any particular expertise with firearms or shooting is just nonsense. They might, but you can't just presume that. The sheriff needs to study with Andrew. Yeah, that would be nice. Paul says those glass doors aren't cheap either. Yeah, some of them are very expensive. Is a civil suit by the pool boy a possibility? Sure. I mean, yeah, it's America. Anybody can sue anybody, really. The defense by the homeowners would be that the pool boy was actually a trespasser, that he didn't have license to be there. As a trespasser, he wouldn't have much privilege to sue. Let's see. Paul says, reckless endangering seems like to me he couldn't see anything out there, just blasted away. Yeah, there was nothing to see out there. The pool boy was gone for those last 28 rounds. What's beyond the shuffleboard court? This is what's beyond the shuffleboard court. That red triangle would be the kind of the arc of the trajectories of the rounds. Those are all homes out there. Did they look for bullets in the neighborhood? I don't know. It's hard to believe that they all just disappeared, that nobody found a hole in their house or broken window, a hole in their car. 28 rounds, folks. Yeah, there was no pulling on the door or anything like that. That would make this a completely different case. Yeah, sorry about that. I forgot to click over on one of the pages, but I think that I was talking about, but I think I went back and covered it again. Jeffrey says, are these legal presumptions of a reasonable fear of imminent deadly force harm rebuttable? It's interesting you ask that, because I would say in every state they're rebuttable. In general, legal presumptions are not fixed, they're not absolute, they're rebuttable. The prosecution can attempt to overcome the presumption. I have seen case law in Florida where an appellate court said this particular legal presumption for defense of highly defensible property, if the conditions are met, it's an irrebuttable presumption. I don't know if that's still good law. I'd have to look at that case again and see if it's been overturned or whatever. Dimitri says this situation is not yet over from no charges being filed. Right, the prosecutor could independently bring charges. If I was his neighbor, I would want his firearm rights suspended for putting myself in danger on a hunch. Yeah, I wouldn't want to live near this guy, right? With my wife and kids in that neighborhood, in that red triangle there. Nope. Yeah, bullets always find a target. They always hit something. KT asks, if someone in a house in the red triangle area hears the 2 shots, thinks someone is shooting at me, then hears the 28 shots, can he shoot back? Is he justified in shooting back? I mean, maybe, but what would you be shooting back at? Right? You'd have to see what you're aiming at to see the threat that you're intending to neutralize. But if someone's shooting at you and you reasonably perceive them as an unlawful threat of death, imminent death, or great bodily harm, you can defend yourself. That's just a straight up self-defense scenario. Even if the person firing the shots in your direction is acting lawfully themselves. That would be a legitimate lawful but awful situation. And it's not that uncommon. 2 people acting innocently, firing shots at each other, they're both legally justified. Let's see. Joe says, when I lived in Annapolis, had a neighbor who was a Navy commander. He was a JAG lawyer. We all know that lawyers don't know anything about guns. Well, a few of us do, Joe. In fact, I have a new AR upper arriving today. I'm very happy about that. Richard says, I was a combat engineer in the Corps. I mostly built stuff like bridges, roads, but also trained as a grunt. Steve B says, Andrew, while your analysis is spot on, and perhaps this was a perverted backhand slap at self-defense laws, but assuming the sheriff is being straightforward, it's refreshing to see prosecutorial discretion in favor of a defender. I would lean that way for the first 2 shots. I can't see any justification for the next 28. The pool boy's gone. There's no evidence to even innocently, mistakenly perceive as a potential threat or breach of the home. Mike says, I really didn't like the part where he said he didn't have a round in the chamber, so he wasn't meant to hurt someone. Yeah, so the sheriff was saying, well, he wasn't gung-ho to be shooting. And I can tell that because he didn't have a round in the chamber. And I guess if you have a stored rifle with a full mag, you might not want a round in the chamber. I mean, it's pretty quick to chamber around. And if it's a long gun situation, you had time to get the long gun, right? You're not carrying it around on your back inside your house all the time. But I don't think having a round or not having a round in the chamber, in the gun, in the safe, or wherever you store it, is any indication of your state of mind in the moment that you're wielding the gun thinking you're facing a threat. Yeah, they actually give the address in the press conference, which I thought was interesting. 41 Concord Drive. What the hell is the name of the town? Dunedin, I think. And that's the house I have pictured up here at the top. Gary asks, would you agree that it's legally risky to fire through a closed door? Yeah, I mean, it's legally risky to fire, right? And the risk doesn't get better, doesn't get reduced if you're firing through a closed door. I would want pretty explicit evidence that that door was coming in to the house before I'd even consider shooting. And I'd probably want evidence that the people coming in have guns. But maybe not. I mean, someone kicking your door is a pretty unambiguous situation. Let's see. Zachary says, what are your thoughts on using a 223 or 5.56 rifle for home defense? Are there advantages, disadvantages to a particular firearm? I mean, people get emotionally invested in these choices. So I don't tell people what to use. I don't tell people what to do. So I would suggest that, you know, although even in home, a gun is rarely. I've never needed to use a gun in defense of my home, but I've got them because if a gun is the answer to the problem, it's generally the only answer. I'm much less concerned about whether it's a pistol or a shotgun or a rifle. I think most of the problem is solved just by having a gun. And then we're getting nitpicky. I don't have any problems with using a 223 or 5.56 for home defense. That's probably what I would do if I had the time to access it. Generally, I have a pistol on my person, so that's my go-to. Should it come to deadly defensive force. But if I had just a shotgun, I mean, a 12 gauge, obviously I have shotguns. Would I feel I was adequately defending my home with a Remington 870 12 gauge? Sure. I think I'd probably, if I had to pick between that and an AR platform, I'd probably pick the AR platform, just more BBs in the gun. But all those choices are fine. Eric says, I'm going to be taking my CCP class. I guess hopefully that's a concealed carry class and not a China class. Besides the class itself, what resources can you recommend for practical advice on everyday carry? Well, holster, clothing, storage. I mean, people write whole books just on that, Eric. For training, I would encourage you to get. There's a lot of bad training. I mean, we live in a great time. There's so many self-defense trainers out there, and many of them are good. Many of them are not so good. There's a lot of people just making stuff up and pretending it's like earned expertise. They're just often repeating nonsense that other people are saying. So I would encourage good quality training. Mickey Shooks at carrytrainer.com. Why don't you check out his website? He does a whole bunch of different kinds of classes. I've been to his. I've taught at his. I think it's a 4 or 5 day, like a week long S12 course. He teaches a couple times a year. And so I've seen what he teaches, and it's top shelf stuff. He knows what he's talking about. And he can, somebody like that can give you good recommendations. The truth is, with holsters, they're so personal that, what works for me wouldn't necessarily work for you. So body type, how you prefer to carry, when you prefer to carry, all that kind of stuff. In terms of clothing, you just have to, it's just experience, folks. I have boxes full of holsters and belts and gear that I just don't use anymore. Yeah, Richard says, Eric, plan on buying at least 5 holsters before you find one you like. And 2, you have to radically change your entire wardrobe to accommodate carry in most places, in most cases. Yeah, that's pretty true. KT says, question, could the pool boy shoot back? Yeah, again, the question is, would the pool boy be reasonably perceiving that he was being subject to an unlawful, imminent threat of deadly force harm? If the answer to that is yes, he can shoot back. Zakuza said, damn you, Branca, you shared a Palmetto State Armory tweet, and I ended up buying 2 guns from them. Yeah, they're terrible. I have to block their emails. Palmetto State Armory does a lot of, they sell firearms of various kinds. They make very inexpensive, I would call them utility grade AR rifles. You get a nicely operating AR rifle for like $500. I mean, it's fantastic. Now, are they world-class quality ARs? No, but a world-class quality AR is more like $2,000, $2,500. So if you have that kind of dough, go to Wilson Combat or wherever, get yourself a very nice AR. If you don't have an AR yet and you have $500, it's hard to go wrong with Palmetto, honestly. Let's see. Yeah, and they have Palmetto also. I think they have their own version of a Glock-like pistol, a polymer frame pistol that I've never shot, so I don't have any personal experience with it. But if it's of similar quality to their AR stuff, it's like $250, I think, or $300 for a 9mm pistol, concealable pistol. It's amazing. If someone just spontaneously as an adult popped into an existence and needed an AR and a 9mm pistol on a budget, I would definitely send them to seriously consider Palmetto. All right, I think that's everything. That's everything I wanted to cover. I'll just put the membership thing up one more time. lawofselfdefense.com/trial, 2-week trial membership to unlimited access to all our members only content, thousands of blog posts, videos, podcasts. Try it out for 2 weeks for just 99 cents. If you stay a member, it's less than $10 a month to be a Law of Self-Defense member, folks. All right, with that, I will remind all of you once again, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, tomorrow, we got a show lined up for tomorrow. Until what is tomorrow's show? I do so much content. It's crazy. Tomorrow's show, I will say, is pre-recorded because I had some scheduling conflicts. So I recorded tomorrow's show yesterday. Let's see. And it's I can't even find it. Hold on. It is. Oh, yeah. Okay. It's a show in which I cover a whole bunch of use of force events that were captured on video. About half the show is non-shooting stuff. It may involve guns, but no guns are fired. And the second half of the show is actual shooting events where people are shot. So that'll be a split show. So the first half of the show is available to everybody. The second half of the show only to Law of Self-Defense members. So another good reason to consider becoming a Law of Self-Defense member. And that'll go out at 11 a.m. Eastern time. Because it is pre-recorded, I won't be taking questions live like I did today. But sometimes that's just the way we have to do it, folks. All right, so folks, until tomorrow's show, until next time, I wish you all a safe and happy week. Keep enjoying your summer and stay safe. Bye-bye.